So I will call this meeting to order. This is Crystal Kennedy, and this is the meeting of the Community and Economic Development Committee meeting. And today is Thursday, January 7th. So on our agenda today, well, first let me say, I know we have quite a few people with us and we need to take roll call. So let's do that first, even though we kind of all chimed in already. But anyway, for the record, Mandy, could you please call the roll for us?
Yes, ma'am. Mr. Weddleton?
Here. Oh, I am muted. Here.
Ms. Kennedy?
Here.
Mr. Peterson was excused. Mr. Constant?
Here.
Mr. Dunbar?
Here.
Ms. Salatel?
Here.
And for non-committee members, Mr. Rivera? Mr. Perez Verdia? Ms. Allard?
Here.
Ms. LaFrance? Chair, you have a quorum.
All right, thank you. And I see we are recorded, so I didn't mention anything about the recording, but it does say that we've started the recording, so I'm assuming that's correct. Okay, so we have several staff members with us. I suspect we have some members of the public, and we're going to get through our first order of business, which is the marijuana application. And we may have some people here with us that will comment on that. And I'll just have people introduce themselves as they need to. And then when we get into more of the conversation, you know, on this municipal right-of-way and easements, then we'll ask people to introduce themselves then as well when they begin to comment or ask some questions for us. So anyway, so let's go ahead and start up with the marijuana establishment application. And so this is with Voodoo Cannabis. So if you want to start us off, Ms. Honest, that would be great. And I do believe we have Ms. Howard with us. So we may be able to ask her some questions if there's anything in regard to the specifics from the owner. So Mandy, can you please go ahead and give us kind of the info on the license? Thank you.
Thank you, Madam Chair. So this is Voodoo Cannabis Company. This is a new retail marijuana establishment license application. The general restrictions were all addressed in their operating plan. There were not any taxes, fees, or fines found due. They also addressed all of the safety and security requirements in their operating plan. The retail specific license restrictions were addressed as well. And so there were no additional conditions requested for this license.
All right, thank you. Any particular questions yet on that? If not, we'll move on to Mr. Yell and the land use permit. Let's go ahead, Ryan, and do your part, and then we'll take all the questions together when you're finished. So if you don't mind, please go ahead.
All right, thank you, Madam Chair. Good morning. So this is a request for a special land use permit for a marijuana retail sales establishment within a B3 district. This site is located northwest of the intersection of Gamble Street and East 10th Avenue in Anchorage. And the proposed establishment, the proposed establishment will be located within an existing commercially designed structure constructed in 1970. The licensed premises area will be approximately 360 square feet, and the proposed business hours of operation will be 7 days a week from 8 a.m. until midnight. The planning department did mail out 248 public hearing notices in accordance with the noticing procedures of Title 21. When the staff report was written, no responses from the public had been received at that time. However, one public comment in opposition was received after the staff report had been finalized, and this comment will be forwarded to the Assembly so that you can review it on Tuesday. public hearing notice was also mailed to the Fairview Community Council, and the Fairview Community Council did not choose to submit any formal comments on the matter. The Planning Department does recommend approval of the special land use permit, subject to the conditions as stated in the staff report. And I'd be happy to take any questions. Thank you.
All right, thank you, Ryan. Okay, do we have any questions from the committee on this retail establishment license? And this may be a very simple and straightforward one. So, and we do have the owner here with us. So, Ms. Howard, I'll let you say if you have anything you wanted to add or tell us about, but you're more than welcome to comment if you'd like.
Thank you very much. The only thing I have to add is I'm looking forward to joining the Fairview community and being a responsible business owner in that area.
Great, thank you. Let's see now. Looks like we've got some people lining up in the queue. Mr. Weddleton.
Yeah, thanks. Ryan, could you summarize briefly what the objection was that you received?
Sure. So through the chair, the comment that we received was in opposition. The comment briefly stated that they felt that there were too many marijuana establishments within the area already, and they were concerned about the litter that's been noticed around, I guess, some marijuana retail facilities, the plastic tubes that the pre-rolls come in. They had some concern about those tubes being kind of broadly cast around.
Okay, thanks. We have one more briefly.
Well, go ahead, John, and then we've got Mr. Constant. So, Mr. Weddleton.
Okay. You know, there was a comment from Solid Waste Services that said you need to revise the your trash. I think your trash said you were going to store it inside and maybe dump it on your own or something. I didn't go back to look again, but did you work out with Solid Waste Services? And I guess this is to Ms. Howard.
Okay.
So my last conversation with Solid Waste Services was that we were meeting their requirements. Initially, I think somewhere in the code it says that we have to have garbage pickup. We must have garbage pickup. There's some sort of a ordinance that says that. We went back to them and said, listen, we just asked for the dumpster to be removed because we could not keep people out of it. It was an attractant. People were trying to sleep and do activities behind it. So we just asked for it to be removed. However, that lot shares, there's two businesses on that same lot, and the donut place has their own dumpster. So if we had any non-marijuana waste that we needed to get rid of, we could use theirs. But otherwise, we'll be transporting our own trash.
Okay, and Solid Waste Services is good with that. Is that correct?
They were good with it. She was reluctant to write us a letter saying that we didn't have to have one. She felt like that was not in her scope, but she seemed fine with, or she was fine with with just pulling the dumpster and proceeding with no outside trash from our establishment.
Okay, thank you.
Okay. Thank you. Mr. Constant.
Yeah, thank you. So, Ryan, the complaint that came in, did we have a copy of that somewhere?
Through the chair, Mr. Constant, not yet. That comment was received late, so what I'm going to do is I'm going to attach it to an AIM and then forward that to the agenda staff so that they can include it, so you'll have it for Tuesday.
Who was it that made the complaint?
It was a Mr. Bitney.
Really? John Bitney?
Yes.
That's very unusual and interesting. Okay, thank you very much. So if we're done, I would recommend approval. I move to recommend approval.
Okay.
Second, Zalatal.
Okay, second. Is there any opposition? Okay, well, hearing none, then Ms. Howard, what we do is we'll make the recommendation to the full assembly, but your license goes before the full assembly on Tuesday. So if there are any other questions or anything, anybody from the public wants to comment, that'll be their opportunity as well. And you are more than welcome to attend also. Let me see if there's anything. Oh, so any other questions though, before we let this one actually go?
Miss Kennedy, this is Miss Allard. I have a question.
Sure.
This is for the owner or soon to be owner. Could you tell me, do you know by any chance of the nearest location of other marijuana shops in that area by chance?
Sure. There's one on 15th. I don't know if you're familiar with where Dooley's used to be. It's between Inger and Gamble. So there's one there. And there's one really close to Lucky Wishbone on 5th Avenue, I believe that is.
Could you give it to me more of
Distance?
by yards, maybe? Yeah. Can you do that for me?
So I'm on 9th and Secret Garden is on 15th. So that would be what, 6 blocks? So I couldn't tell you as far as feet goes, but that's definitely 6 blocks. And then the other one, Alaska Buds, is at least because it's over a ways, it's at least 5 to 6 blocks away. So I'm sorry, I can't feel better feet.
No, that's perfect. Thank you very much. I appreciate it.
All right. Thank you, Ms. Allard. Mr. Constant, back in the queue.
Yeah, there's actually one additional one in the old Rice Bowl building. None of them are within maybe 10 blocks or 8 blocks. And, I just want to share an anecdote of what cannabis shops are doing in this neighborhood. I know that this petitioner has participated at the Fairview Council for the last 8 months or so. And this is a total sidebar, but of note and interest to this question, I think. The concern of too many in a neighborhood, whatever that means, the code doesn't speak to that. But I had a neighbor send me a note this week because somebody had dumped a box of medical waste on the sidewalk near their home. They could not, after calling Solid Waste Services, Muni Works, AFD, anybody at the municipality to get help to get this box of medical waste off the street before it scattered to the wind with needles and gross things. They contacted me. I reached out to the owner of one of these cannabis shops, and within 5 minutes, that box was safely removed to a secure waste basin. And so anybody arguing that there are too many in this neighborhood aren't paying attention. These folks are improving our neighborhood, and they're doing it out of their own investment and their own goodwill.
Well, thank you, Mr. Constant. Mr.
Thank
Yell?
you, Mr. Constant. Can I say something really quick?
Ms. Allard.
Thank you, Chris. I appreciate it. And sorry if you thought I was arguing about it. I did see that post and it was much appreciated. I was just trying to get a feel.
Not you, just generally.
Oh, okay. All right. Thank you, Mr. Constant. I appreciate that. And I did see that post about the needles, and that was amazing what the business did for that district.
All right. Thank you, Mr. Yell. You had a comment or a question?
Yes, thank you, Madam Chair. I just wanted to clarify, I could also share my screen here too and pull up the municipal marijuana establishments map if that would help committee members as well. But the nearest retail facility to this location is approximately 1,300 feet away, and that would be the Alaska Tasty Cannabis, which is in the old Rice Bowl on East 6th Avenue.
Well, Mr. Yell, since you have your screen available, go ahead and do that. And everyone will get the visual picture of that.
Okay.
Thank you.
Okay, so we have 930 Gamble Street, which is the petition site in this case. At the center of the screen, we have Secret Garden Cannabis, which is at the bottom of the screen. It's that green square that's on East 15th. And then we have Alaska Tasty Cannabis, which is at the top of the screen on East 6th Avenue, as well as Alaska Buds. If you can see my mouse, circling that.
Yes.
And Then, of course, we have, I believe, Tip Top, Tenelli Dispensaries and Satori on East Fifth Avenue. And I can't recall the names of these two, but Green Room AK and Tundra Herb Company. So just a general overview of what's in the area.
Great, thank you. I appreciate that. So, okay, then again, before we let this one go, any more questions or comments? All right, so seeing none, hearing none. Thank you all. Thank you, Ms. Howard. And again, the full assembly will see this on the agenda on Tuesday night. So thank you for being here with us. All right, so we're going to move. You're welcome. We're going to move on to the opportunities for use and development of undeveloped municipal rights-of-way and easements. We're really just kind of opening this up to a general discussion at this point. Nothing really on the agenda that we're trying to wrestle with. But we do recognize that there's probably a good need for getting some more information about what kind of rights of way and easements that we have that basically allow for public access. I think we've got, let me see here, look real quick. Do we have Mr. Schutte with us? I know that yes, we do. I know there's really nothing that's been formally prepared for this conversation, but because there's been a lot of community interest in some of the public access facilities or locations within the municipality, we thought we should probably get a good handle on what our requirements or restrictions, what the code says, maybe what state statute says. And so anyway, it's just a real general conversation right now. So without there being any real presentation, Mr. Schutte, would you mind just kind of just giving us a kind of a jumping in point here on this, whereby we can kind of have a discussion about what kind of questions we might need to be asking, what kind of information people would like to have. And anyway, just kind of get us started here. Do you mind?
Good morning, Chris Schutte, Director of Economic and Community Development. I think by way of getting started, one of the conversations that I had with Co-Chair Weddleton yesterday was about trying to understand what the various forms of public access the committee would like to cover, what those are. So perhaps hearing from whether it's from committee members or from some of the participants who have an interest in this issue that's specific to their particular public access question would be a good way to start. Public access has taken many different forms across the municipality, and it depends on the type of access that's at issue, whether we're talking about access to Chugach State Park, for example, or access along things like unused rights of way, or in the case of the state, section line easements, et cetera. So I recognize that's not much of a good introduction. I apologize for that, but really I think the conversation today would be helped by understanding what are the various issues or access issues that we're trying to address, and we can be a resource in that conversation. Thank you.
Yeah, no apologies necessary. No, I appreciate you jumping in. You know, this is very interesting timing, I think, and I was talking to Mr. Weddleton as well in regards to this a few days ago. And timing wise, it's very interesting to me that JBER is trying to do a real comprehensive look at the various ways that people are accessing, the public is accessing JBER property. I also had a conversation this week with the state, and they are very interested in finding, identifying for the public's knowledge, the actual places that are considered public access for Chugach State Park. And I know that's an issue for my community, especially down Eagle River Valley. And so I just really appreciate the fact that this is obviously getting a lot of publicity right now, and the need for identifying those places and helping the public as well as property owners understand exactly what that access is or isn't, I think is going to be really helpful. So the fact that we do the same thing here at the municipal level will also be just as helpful. So I think we're probably going to end up giving some questions in regard to how we do go forward with this. And to start us off, it looks like we have Ms. Zolotel.
Thank you, Chair. So my question's probably more fundamental, and it's taking us even a step further back, is there a way to look, particularly within our districts, for public rights of way and access points so that we can better educate ourselves about those that are around before they possibly become controversial, and just be more aware of them?
Mr. Schutte, you want to take that question, or if there's somebody else in your staff that...
Sure, I'll get started, and if someone from the survey section is here or GIS, they can jump in. But I always like to start by referring people to the Maps and Apps Gallery. It's the GIS repository for the municipality. Contains a lot of useful maps. Within that, there are ways to survey your districts and identify, based on the rough renderings of property lines, et cetera, where there are rights of way or platted rights of way that may not be developed. So a road, for example, that was only constructed, say, half the total distance of the right of way, those would be visible on some of the property maps within the Maps and Apps Gallery. And then, of course, there's a lot of, I guess I call it institutional, but anecdotal knowledge about where access points or underutilized rights of way are within the district that you can get from your neighbors, really. So there's a couple different resources. Many of them are hard to find, but are well known anecdotally. But the survey information that you can find through the GIS gallery is going to be a great starting point as well.
Is that helpful enough, Ms. Zolotel?
Sure, and I'll take that as maybe an invitation when I start to get into the GIS to ask for some more help. Thanks.
There is a lot of information there, and I agree. Sometimes it's hard to know which one of those maps to actually click on to get the information you want. So we could probably all use a little more clarification or a lesson on that. So we'll keep that in mind. Mr. Constant, I have you next.
Yeah, thank you. I just want to make sure to put a point on the record that this conversation is the first wave of response to the public testimony we received, in which members of the public requested that we address issues of Campbell Lake. And so the chairs, probably wisely, I certainly won't argue with it, have opted to take a more broad look first before we move into anything specific. And I think that's fair and reasonable. And so this is definitely part of that conversation. So I just want to make sure that's part of the record. And I see that Nancy Peace has put a question in the chat. That's probably, Nancy, there will be a time for comment. So anyhow, I just want to make sure the record reflects that this is that conversation begun. Thank you.
Thank you. Yes, we're going to have an extended conversation about a lot of this, and I'll make some comments on that in a little bit. Mr. Weddleton.
Oh, thanks. So a couple points. I wanted to address Meg. I've looked a little bit at the muni.org GIS stuff, and my go-to for many years has been anchoragelive.com. And you can, and just going through my district or my neighborhood and looking at lot by lot, it's kind of clunky by modern standards, but I could find in some of the neighborhoods I've lived in where there would be connections just between roads, even, that would be nice walking connections, and some are road right-of-ways, some are actually trail easements. But over the decades, they've been usurped by the neighbors who probably just don't know. You know, they just, when they bought the house, the lawn went over there and then they put a shed there. And now it's essentially uncomfortable for the public to use it and not really very clear. But, you know, that's something, you know, if you like to do that kind of thing, is just kind of click around Anchorage Live and see what lines might be there that aren't clear when you're on the ground. But that's one of the, and a lot of those would be really handy walking routes to cut the distance to getting to schools and so on. So, so it'd be nice if there was some way where we could address those in a formal way. And, you know, and I think it can be uncomfortable in some cases because the homeowner thinks it's their property and now they'll have a trail and not everyone will be happy about that. Anyway, thanks.
Yeah, thank you, Mr. Weddleton. We are going to go to members of the public, but if I can get through some of our assembly member questions first, I think that would be good. So, Mr. Dunbar.
Thank you, Madam Chair. So I have a question for Ms. Vogel, the municipal attorney. I think she is in the meeting. Ms. Vogel?
Yes, I'm here.
Wonderful. So we have received emails with assertions. I think they're usually forwarded to us, not directly from them, but from folks on the lake asserting that this is not a public lake and that the public has no legal right to access it. Is that the case? What is the legal?
Oh, I can.
Can you give us the legal analysis of it?
Sure. Thank you for the question. This is Kate Vogel, municipal attorney. So last year, the state and the municipality together evaluated the legal status of Campbell Lake because it was claimed to be a private lake and had been for some years. But that's not a normal thing in Alaska. And so then there was this question of how did this come to be, and is this sort of supposition, a supposition which is held quite strongly by the owners and has been, and by owners I mean the owners of property along the lake, and that's been a supposition for many years. People bought property under that understanding. So there was a deep inquiry taken, again, jointly by the municipality and the state into the legal status. And the conclusion was that this is public water, as the general conclusion is that water in the state of Alaska belongs to the state of Alaska. You can own the land underneath the water, but just sort of similar to the air column above where planes are allowed to fly, the water column is something that in the state of Alaska, the state has long asserted belongs to the state. Then there was a question of, is there any public access to get to this water? And investigation showed that there are two points of public access. There's a northern section line easement, and there is a southern easement that is partially a pedestrian easement and partially a section line easement. We, as the municipality, control access along that, the first start of the southern easement, and then it turns into the section line easement. And that plus the northern section line easement are generally under state control. The state is the one who sort of maintains the rights associated with that easement for the public trust. So those were the legal conclusions that were reached last year. These conclusions were not pleasing to certain individuals who have property interests along Campbell Lake. And some of those people have hired lawyers to assert that the analysis conducted by the state and the municipality is incorrect. They have not brought suit anywhere. They have written some letters. None of the letters that they have written have changed the minds of the individuals at the municipality or at the state who've conducted the legal analysis. And if they wanted to sort of change that, they would need to bring it to court, which they have not done. I would point out that most of the legal analysis that is at issue here is about state law, state water law, state law regarding section line easements. If there is a court battle about this, it will largely be, and maybe entirely be, a lawsuit involving the state, and the municipality has a significantly smaller role, although certainly this office and my predecessor conducted the research and concurred in that legal analysis. So I would say I understand that not everyone agrees with it, but the way to get the state to reverse a position on is something a public access is to bring it to court and try to change the state's mind there, and that has not been done. I don't know if that fully answers your question. But.
No, that's perfect. Thank you, Ms. Vogel.
All right, thank you, Mr. Dunbar. I have Mr. Gates in the queue as well. So Mr. Gates, go ahead.
Yes, thank you, Madam Chair. Well, first I was going to comment when Mr. Welton was speaking, and I think I need to disclose that I'm conflicted out from working on anything related to the Campbell Lake matter. So I'm not going to speak to that specifically, but I want to speak to the general idea of rights of ways and the public access easements just generally throughout the municipality. And my comment was generally that there's legal access and physical access, and both of those have their own issues, and sometimes legal access is clear, but there's no physical access. Like some examples Mr. Whittleton mentioned, where people develop across where there's the right of way or need otherwise some established legal easement, but they've got a structure and so forth, so it becomes a physical access issue, and sometimes people end up in court to assert the legal right and so forth. And sometimes the legal right, legal access isn't really clear, or there's conflicting recordation or recorded documents, or the recorded documents are not specific enough, things like that. So I think that that's what a lot of people see is they assert legal access, but maybe it's not really perfected, or there it is and there's no physical access, and struggle to get that. But sort of like what Ms. Vogel said at the end of her comments recently, people end up in court to sort those all out. But my general comment is just those two different things, and aren't always congruent with each other, legal and physical access. And I do need to sort of make a caveat. I have not researched this issue yet, and we have a lot of experts. So, like our municipal surveyor, Steve Schmidt, and folks in the planning department. And of course, we've got the law department that did a bit of research on this already.
Thank you, Mr. Gates. And I'm going to comment here as well. I am hearing rumors that they do believe the lawsuit will be coming pretty quickly here. And I think a lot of what we're going to have to do is wait till the courts decide what they're going to decide on that. So I don't want everybody to get too worked up about what we're going to do, because I think we're going to have to wait till that decision is made. The other thing I will say is the state does still stand by the joint statement that they made with the municipality. Like I said, I talked to them this week. And the formal statement that they made back in December of 2019 is still their position. And the document itself, for those of you in the public, I believe, and Mandy, you can correct me if I'm wrong, but I believe it's actually on the municipal website under the Community and Economic Development Committee. I think it was posted there specifically for this meeting. And otherwise, if somebody needs the copy, I'm sure we can get that from the legal office as well. So just want the public to know that what we're talking about is available to the public. And then, Ms. Vogel, I have a question that you might be able to research, or maybe somebody even from other staff know about this, know the answer. But there's a statement in this joint statement that says that the dam above Campbell Lake is actually jointly owned by the Campbell Lake Owners Incorporated, which I'm assuming is their homeowners association, and the municipality. And I was wondering what kind of document we have that asserts that ownership or establish that ownership. So if that's something that we could maybe get some detail on, you know, kind of when that arrangement happened, what that document actually is that establishes that ownership. I'd be interested in knowing that. So that's my question. But okay, Mr. Constant, you're next.
Yeah, thank you. Sorry about that delay. You know, Mr. Gates, I think, and you just pointed to what I think we're looking at as a timeline and process, that there is legal questions around this property, and that there are two things here. Is there legal access, and is there functional access? And if there is legal access, is the muni preparing to provide functional access? And I think that that's really the rub of what the individuals who are coming to us asking for us to investigate this question is, what is the method for them to access this lake? And so that again puts into relief why we need to allow the legal procedure to move forward, but barring any legal action, because I've been hearing legal action is coming for 2 years, at some point the muni does have a responsibility to figure out what the method for access is, because we will continue to have conflicts between property owners and members of the public who wish to access the lake, and will do so on the right of way that they believe to exist and that our municipality and the state have asserted does exist. And so that is literally the rub of this conversation. And so just want to put that out there.
Yeah, well put, Mr. Constant. Thank you. Mr. Weddleton.
Well, thanks. Sorry, I got to check to see if I'm on mute.
We hear you.
Okay, thanks. Well, just following up on that. So Chris kind of caught my question there. Is in any case, and not just Campbell Lake, you know, I think there could be hundreds of little rights of ways and easements that have been usurped, and maybe there's no physical access, or just they just haven't been used. What is this would be a question to Chris Schutte or someone on staff, you know, what is the city's policy if it's pointed out that, hey, this is a pathway easement, it's blocked, it should be unblocked? What does the city do? And if there's so many, how are those prioritized?
And Mr. Schutte, I don't know if you want that question or somebody else.
Yeah, thank you, Madam Chair. I can't see all of the attendees. Is Jack Frost online?
I don't believe so, unless he's a phone number that we can't identify. But otherwise, I don't see him. Mandy, do you happen to know? Doesn't look like. I think if you were.
That's my sister, Rebecca.
I'll go ahead and provide a high-level response to the question. And the short answer is if there are impediments to a public right-of-way or easement, like a pedestrian easement, then a member of Jack's team would would arrive on site, would document the blockage, and then would work to either remove the blockage, or in the case where it's known that the impediment was placed there by, say, a neighbor, they'd work with the neighbor to educate them on the existence of the easement or the right of way, and have them remove the blockage at some point. So at a high level, that would be the typical response. Thank you.
Any follow-up, Mr. Weddleton, or do you want to wait till maybe we can get more detail from Mr. Frost?
Well, I guess we'll wait. You know, I mean, it kind of says, okay, I guess they tell me it's in the arena of code enforcement to do that. And that's an important point. And then, you know, they're stretched thin doing so many things that, you know, they just can't, you know, if we got a list of 100 of these, that's huge. You know, the staffing's just not there. And I think at least at some point we should consider, how do you prioritize which ones and when? And so maybe that's just a question to carry with us as we move forward.
Hey,
Thanks.
Sure. Thank you, Mr. Weddleton. Any other questions? I'd like to get to people that we have here from the public. So, All right, I'm not seeing anything. So let's open this up to some of the questions from the public that maybe we can get some answers to, or at least at some point get some answers to. So Ms. Pease, I think we have you interested in posing a question. So please go ahead. And just identify yourself too, please. And if you're on a phone, you need to hit *6 on your phone to unmute yourself.
Can you hear me?
Okay, yes, we hear you.
Great. Yes, I'm Nancy Pease, and I've been involved in promoting trails and pedestrian access for a number of years. And I'm so glad you're having this meeting. Undeveloped pedestrian easements are a stranded asset at this point. Because they do not lie within road corridors, traffic planning and project management and engineering largely don't advance them as transportation projects. Maintenance department largely doesn't maintain them, and they're not under parks jurisdiction because they're not within park boundaries. In both the compact urban areas and on the hillside, these undeveloped pedestrian easements, including section lines, should be considered an essential part of our transportation system. I'm a hillside resident, and on the hillside, terrain such as creek ravines and steep slopes often preclude connecting a standard road grid, but these pedestrian connections are practical, they're convenient, and they're relatively cheap compared to roads. And I think we all know the economic benefits of trails, given that real estate ads and employment recruiting tout proximity to trails is a big selling point. And that's in addition to, of course, neighborhood cohesion and safe, healthy alternatives to driving, and even relieving overburdened trailheads at Chugach State Park if people can walk in their neighborhoods or get to the parks by foot. So with regard to what's needed by the municipality, and this is short of any lawsuits, how can the municipalities departments recognize these assets and begin to develop them as infrastructure for the benefit of the public? And what I'm hoping the municipality will begin to work toward is some sort of a template for partnering with citizens groups or nonprofits who initiate public trail corridors along existing undeveloped easements. I mean, it'd be great if these were actually considered projects and they were advanced through the capital improvement projects and that sort of method with bonding. Short of that, there are neighborhood groups who want to start developing and using these easements, and we're hit with very formal application process for similar to a road construction, with requiring $150,000 of bonding and insurance. There are no supports. There's no template. We're told that we need to survey the route immediately. Well, we don't even have any complete plan. There's no outreach to the neighbors, template for outreach to the neighbors. So we're really looking at how can these, as I said, stranded assets become part of our infrastructure development. And then on a second note, after they're developed, how can they be put into the transportation maintenance stream? So that's, I guess, generally the big picture that we're looking for help with. And on the topic of identifying these, the GIS map layers are not very complete. So that is also a problem. Haven't tried Neighborhood Live, but I guess I'm looking for some feedback as to how, groups, as I said, from citizens, from neighborhoods, and we do have a couple projects here in South Anchorage in my Rabbit Creek, Golden View area, where we'd like the municipality to become a partner and to apply for section line use from DNR for a safe route to schools and parks. So we need at least a liaison, and hopefully someone who can, we're willing to be a pioneer, but we're looking for a process.
Thank you, Ms. Pease. I appreciate the information on that. And, I think you're absolutely right. I think that's part of the challenge here right now, is to really understand what the Muni does have and what is the responsibility of the Muni to make you not only claim that we have these easements and rights of way, but to make sure that they actually render the kind of access that the public expects. So, and you're right in terms of there needs to be more maybe general policies. You're not necessarily trying to pick on any one location, but we need to really have a better understanding of what public access really means. So so thank you for summarizing that for us, and we definitely are going to have more conversation about this. I mean, I think that's all I can say at this point, is that we definitely are recognizing how much more we need to work on this. So Mr. Weddleton has put in the queue the anchoragelive.com that he referred to, just so people know that that's been put in the queue there, or I put in the chat, I should say. And there's a question then also says, can someone please identify who at the state is your contact and if they're cooperating or meeting with your committee? And I will say that the state is, the DNR is the division, and they are not making any kind of formal statement or anything just in regard to Campbell Lake, other than what they have already stated. And that's not necessarily, they are not meeting with this committee. It was just a contact that I had that I made on my own. So we'll, Mr. Constant, you're in the queue next.
Thank you. Just a response to Ms. Peace. You know, your request for an ally, I am here and I am going to continue to ride this question until we have solid answers, whether we're talking about Honey Bear, Stewart Road, Campbell Lake, or any other place where we can identify that there is either a question and controversy or an actual taking of public right. I look forward to being that ally for you in this process.
Thank you, Mr. Constant. Thank you for stepping forward with that, because yes, she was definitely requesting some kind of liaison. So as always, there always needs to be someone that, you know, follows through on an idea or a request. So, and I know that this committee is going to do more of that as well, just because, you know, we're bringing it up right now and we're asking questions of the staff. And as we get those answers, I think we can probably start to figure out a path forward, just in terms of what the municipality can do, or we as assembly members can do, to make sure that public access is actually publicly accessible. So anyway, any other questions? Is there anybody else from, oh, okay, I've got somebody, Lori Barter. So Ms. Barter, if you want to go ahead with your question, please do.
Yes, thank you. I was one of the residents of Resolution Point that testified at the December 8th Assembly meeting and posed several different questions. You've addressed several of them today, and just appreciate you bringing this to the committee as quickly as you have, and look forward to resolutions and trying to figure out how we can possibly have access to this south easement of Campbell Lake, even this winter, if I know that's asking a lot, but and Mr. Constance, appreciate you for taking the lead on that, and we definitely look forward to hearing the outcome on this. Thank you.
Thank you. And Ms. Barter, before you go though, was there anything that, I remember your list of questions, is there anything we've missed though that you want to highlight that we haven't asked yet, or something that you think we need to get some information on as we try to move forward and put this all in some perspective?
So it sounds like it's pretty general at this point for all easements throughout the municipality, and my questions were very specific to the south easement as far as funding. Is there funding? And if not, are we allowed to use the trail and make our own trail? And that hasn't clearly been stated. So that would be probably the main question that I would have left.
Okay, great. Thank you. And, you know, as always, anything that anybody decides to do usually costs money. So funding is always going to be the question. But that is part and parcel to the conversation that that I think we need to have, just in terms of what some of this might cost and how we fund it. So, okay, now I've got Mr. Constant and then Mr. Weddleton. So, Mr. Constant, go ahead.
Thanks. And I know that the answer to this question will be very cautious and not probably satisfying, but I want to refer that question now to Ms. Vogel. What does a citizen do in order to utilize the access if they operate under the assumption that it exists, but the muni is not in a position to officially act?
Thank you, Assemblymember Constant. This is Kate Vogel. So it's the same status as last year, which is yes, the public does have a right of access along the easements. There is right now an obligation on the public to understand and figure out where those are. And I understand adjoining property owners have not necessarily been helpful with that. When we're talking about the north easement, and when we have become aware of issues potentially blocking that access, that's not an easement that we control. So we've forwarded complaints about that to the state and asked and had repeated conversations over the past several months about some fencing that was possibly in the way along the water. And so, yeah, the short answer is yes, the public, if they can navigate, it's not a developed path. If they can navigate it, they are entitled to. In the southern easement, which is what was just asked about, is pedestrian. So, don't be, bringing motorized vehicles. It's pedestrian, but yes, you can use it. And that said, it is not developed. So to the extent that the question was, can the public build a trail? The answer is no. There's no means right now to just sort of say that the public can self-help themselves into building a trail along the easement, which is I think part of the reason that this is being brought up about how would a trail be developed, how would the access be improved, and those are questions that really invoke liability when you come up with trail preparation, and so that is more complicated. But in terms of just individuals walking, that is permitted officially, and it's the same status as last year. And I understand that the access is not the best, and that's a great frustration to the public.
A quick follow-up.
Go ahead.
Madam Chair. So what about just the simple act of shoveling snow so that there's an actual footpath there? Because I could imagine a situation where the property owners make it their snow dump so that it becomes lunar in character as opposed to accessible.
Yeah, I guess I have not given that any thought, and to me it would be different, depending on are you doing something that could potentially cause damage. So if you are talking about an actual equipment as opposed to a shovel being used, then I'd have a lot more hesitance about whether that was an acceptable sort of action. But if you're doing something that you sort of would be allowed to do in a normal pedestrian walkway, like shovel right ahead of where you are walking, I don't think that would be objectionable so long as you're in the right spot.
Thank you.
Thank you.
So I guess to the speaker or to the questioner, Ms. Barter, the answer is challenging and will take us some time, but reasonable heads will prevail.
Appreciate you.
All right, thank you. Mr. Weddleton. Mr. Weddleton, you may still be on mute.
Sorry about that. Chris is a step ahead of me on that question, so I'm going to charge ahead with points he made. So should someone at any easement, whether it's to Campbell Lake or whatever, decide that, this is clearly an easement, I look at the plat and they start using it and a neighbor objects and there's an altercation, what happens?
To the extent that question is being directed to the legal department, I would say any any altercation that, you know, happening anywhere, you know, requires police involvement, you know, you're sort of welcome to, you know, people can't assault each other, I guess, you know, and so if we're just talking about an exchange of words, exchanges of words are unpleasant. And I think that, you know, leads people rightly to contact their government to try to get the right, more clearly established signs posted. And all of that seems like the right method. We've been asked a lot of questions about trespass and when is it appropriate to call the police. And I think we don't generally want our police being deployed to enforce easements. That's not the ideal use of police. So you should use police if you are in a situation in which you need police aid. People should not assault each other. I think that that's a somewhat unsatisfactory answer, except if you feel like a property owner is very hostile about a public easement, which you have a right to. I think that it's absolutely appropriate to come to your elected representatives and to the municipality and the administration and ask for better signposting and clarification on the easement's existence.
Well, that's valuable. So signs, you got to get the sign makers in action.
I think it would be helpful in lots of cases. Yeah.
All right. Thank you.
Well, thank you, Mr. Weddleton, and thank you, Ms. Vogel, because that sort of answers Ms. Pease's question or comment, you know, about marking the trails with either ribbons or some kind of signage. And so obviously that's something that we have to investigate as well. And I will say that it's not just the municipality that has a role. I know that the state is getting the same complaints. So they're well aware of it, and they have a role in protecting the easement as well. And I think that a lot of that's going to be a little bit better spelled out, both for the state's advantage and for the municipalities. And once, you know, if it does ever come to a lawsuit, that will be helpful. But at the same time, it's very possible that the state will begin to assert its authority and jurisdiction over that easement. And I think that remains to be seen, but I think that is part of the conversation. So we may see more in that vein here soon. So Mr. Constant. Back in.
Thank you. So, you know, the signs and kind of markings, ribbons, etc. It's a good idea. The nexus and the reason why this question keeps coming back to us is because while it is a state issue, these are their rights of ways, and we just happen to be the stage of government in between them and the people. The fact is, enforcement and any engagement in Anchorage is not going to be between the state troopers and the residents and parties. It's going to be between the municipality's police force and the residents. And so there is just this really crystal clear logical challenge we have to face, and that is, it is our problem, even if it is the state's problem. And back to the signs and ribbons idea, is it possible, even legal, would a surveyor take a contract to a private entity to survey on private land that is supposedly a public use access? Because how would we even mark ribbons if we didn't have a survey that determined exactly where those lines would lie, you know, staking of some kind? And so the question really I have there, back to the legal department, is could private citizens organize and do their own surveys, give us the money to do it if they can't? How could we get to the point where we actually have a map on the ground?
Yeah, through the chair, I know that a survey was done at Campbell Lake, for example, and I believe it was privately funded. I wasn't here at the time, so I don't know all of the details or logistical hurdles that were worked out to make that happen, but I know that it was done in the Campbell Lake area specifically. So I might need to chat with you offline to better understand your questions and also understand how we've worked that process in the past.
I make a motion to extend the committee by 20 minutes.
I think we're till 11.
Oh, okay.
Aren't we?
I don't know. The chair just asked for.
Well, maybe not.
I think.
Extension.
Oh, okay. You are
Second.
correct. You're
Okay,
correct.
we're good.
We're good. Yep. Thank you. Thank you, Mr. Weddleton. So Please continue, Mr. Constant, Ms. Vogel, with your conversation if you.
I think what she said is she will get back with me, or we can have a sidebar conversation to start plumbing that question. That the answer was there was a private survey done on this, but then the issue between that private survey and then the question of signs and ribbons is how would the municipality engage in those steps? And so I want to think this through, probably with both legal and folks in the CED department. Thank you.
Thank you. So
Actually, to the chair, point order. The agenda says 10 a.m. to 11:30. But all our scheduling was 9, which we've met at, or I'm sorry, 9:30. Is that right? And
9:30, yes. I'm looking at the
yeah, so I
agenda.
think an hour and a half is
Right.
the plan.
Right, and I think I was thinking that we started at 9 a.m. because we used to do that.
Right.
So, but yes, I'm looking at my agenda right now and it does say 10:30. So I had 10:30 or till 11 and I did have 10:30 stuck in my head, but we're okay. So we're on for another half an hour, so we don't need to extend. So, and I guess I just want to comment too in regard to the state does have a role and they do have enforcement people and they are looking at this issue. So I want to say that I think we do a lot of this jointly and we should probably be supporting each other. If we can decide on what that access is and where, then we all, which is kind of the big question right now, then I think we can both support the fact that people have the right to access this lake. And I think it's gonna, you might, it may become more of an issue if APD is called for a particular problem, but overall, determining and establishing and maintaining that access is also a function of the state. And they do have enforcement people to do that. And I know they have been in there before already, looking at what's been happening, especially in terms of some of the fencing. So I think there's going to be, there will be enforcement if they feel it needs to be, and they have their process for doing that already. Okay, so I want to make sure, I think, Ms. Barter, you had a question that I don't think we've gotten to yet. So if you want to go ahead with your question, please do.
Thank you. Yes, the south easement actually crosses the adjacent property owner's driveway. It has been surveyed. It was marked. Those markings have since kind of dissipated. So it is hard to determine, yet I have walked the easement several times myself, and it's not comfortable to do it because you feel like you're trespassing. But I think that the points have been brought up about the ribbons and markings, and so I look forward to hearing what the outcome is on that. The snow right now, we're trying to basically packed it down in order to get to the lake, making a trail. But yet again, it does cross the adjacent properties owner's driveway. So, and their dock is at the end of the easement. So it just, there are obstacles on this specific easement.
Yes, thank you. Thank you, Ms. Barter. Okay, Mr. Constant, you're back in the queue, and then I have Ms. Allard.
All right, thank you. So I think for a future meeting, then this is the first I've heard that the state does have some enforcement mechanisms availing themselves to these questions. And so I would hope to the chairs that we figure out in maybe our next or one subsequent meeting, an opportunity to invite these folks and have them come to be part of this conversation so that we can do exactly what you, Madam Chair, just reflected would be wise to do, which is start to work closely with them. And so while they may not want to come and have a public conversation, maybe it's wise for us to invite them so we can have a conversation with this other party.
Thank you, Mr. Constant. Yes. Ms. Allard.
Thank you, Ms. Kennedy. To be completely transparent, I've actually been speaking to a few of those owners on the lake, and I agree that Mr. Constant, we should bring them in for a conversation to be had. But I wanted to make the comment I think it was Lori B. I don't remember. I didn't. That's what it says on the phone. But anyways, she was just speaking before Mr. Constant.
That would be Miss
I'm gonna give. Okay. I actually have, our house was built, and the people who built the house, the builders, actually built laid our driveway, and it doesn't exactly say it's on my property according to a survey. And I have an easement that goes right in, the Chugach State Park is right behind my house, and I have an easement actually that folks can come down, use my driveway, and enter onto the main street that I live on. It is uncomfortable. Do I care? No, I don't. And others may, but I don't. And so I understand what you're saying about the driveway. And I guess my question would be, maybe we need to ask legal, or somebody knows who's on the phone right now, was that driveway there before or after? I mean, it would be easy to find out. Did the builders put it there, or did the owners? Because that can determine, yeah, it's uncomfortable. But if it is an easement, we need to respect that the lake, in my opinion, does belong to the community. But does anybody have a response if they know whether that driveway was put in by the owner or by the builder?
Through the chair, the easements that we're talking about predate the development. So I don't know the specific answer of when the driveway was built, but you know, on the northern easement, one of the problems is that the easement itself, it's a section line easement. It goes right through a house that has been built there. So obviously when they were building the house, they were not aware of the easement, but their lack of being aware of the easement does not extinguish the easement. So that's, I don't know if that clarifies the question for you or answers the question.
Yeah, it actually does. It doesn't exempt whoever put the house there as, you know, not their fault or is their fault, but knowing that the easement goes right through their house, that's sort of a pickle that we're in. Thank you, Ms. Vogel.
Yeah, that's the northern easement.
Correct. Okay, thank you. Mr. Weddleton.
Thanks. You know, an easement, I mean, if it's a trail easement, in any case, Jamie prompted this, but they're out there. Then is there a problem having the homeowner? I mean, it's because the easement, my understanding, it just says people are allowed to access, you know, one end of this property, the other on this easement, but that doesn't mean it doesn't belong to the homeowner, and they can still put a driveway there as long as they don't take away from the ability of people to walk on that easement. Is that correct, Ms. Vogel?
Through the chair, Assemblymember Weddleton, I don't want to speak globally, but yeah, generally, you know, an easement doesn't mean that an easement doesn't mean that you can't have a driveway. A driveway is the sort of thing that would allow people to use that space to traverse, which is what this type of easement we're talking about allows. There are, I'm sure, a lot of nuances that I am not getting into about what you are and allowed to do, but generally the issue is one of access, and have you blocked access or permitted access with what the sort of property owner is doing. And so a driveway would not normally be considered something that blocks access.
Okay, thanks.
All right, thank you. Ms. Barter. Oh, sorry, we have Mr. Constant again too.
Yeah,
go ahead.
Thank you. You know, to the point of the question of what happens if the driveway or this or that, I think that the functional challenges, any barricade or barrier that's put in place can be removed, but usually not until there's some public purpose. And, you know, when somebody puts up a fence in an easement or right of way, the fence can be removed by whoever owns that easement or right of way to make access happen. But it just doesn't usually happen unless there's a reason. And this doesn't really help in the south. In the north, where the house is in that easement, there's just no way we're going to be removing a house, right? And so this gets us to the core question of, at least on that side of the lake, what's to be done? And to me, I hope at some point we get to the point where we're contemplating alternative access, because we don't want a cloud to be on the title of that person for now and forever in that house that they bought. And I personally would love somebody like the real estate department to do some title history search on that property and determine how permits were granted when that easement existed, whether it was somebody who made a mistake in the recording or if there was some actual shenanigans by a city department so many years ago in 1970, whenever that property was officially subdivided into use. And so that's another piece that I would love to see happen, is our investigation to the details of how this actually happened on that north side.
And thank you, Mr. Constant. And I will add that apparently that idea of using some other kind of property, some other property for access, was thrown around during the conversation when the legal department and the state came up with the joint statement. And apparently there is some property that the homeowners association owns in common, and there's potential for access there. So again, you know, a lot of work still needs to be done on this, and certainly a lot of legal questions to be decided. But we do need to keep that in mind. If there is potential for other property to be used, what would be the municipality's role in developing that, or even maybe even acquiring that property? So anyway, definitely something to be thinking about. Ms. Barter.
I just need to let it be known that I, as a neighbor of one of the property owners and as a constituent of one of the property owners adjacent to the south easement, I contacted them in good faith and neighborly and was told that the easement does not exist, and that they were working with the Department of Natural Resources to confirm that for the public. I don't know if that's public knowledge, but just wanted to make that known. And so hence another reason why we're apprehensive to use the easement comfortably. But anyway, I just wanted to make that comment.
And thank you, Ms. Barter. And you're absolutely right. There are a lot of things going on right now, a lot of wheels turning, and that's what makes a lot of this so complicated and frustrating, and leaves us with really no good answers, particularly no good answers to tell the public, and that's very concerning and frustrating. But you are absolutely right. We recognize that there are a variety of legal happenings going on right now, and some of it we have to wait on, and that's what's making this so difficult. Any other comments from assembly members? Or from the public on this issue? Not seeing anything in the chat.
Madam Chair, I don't have a question. I just want to say thank you very much for beginning in earnest this process, because it's long overdue.
I would agree with you, Mr. Constant. Thank you. Yes. Mr. Weddleton, you're back in the queue. So.
Oh, thanks. You know, we have an example in South Anchorage in Suzanne LaFrance's neighborhood where there's a green belt. So it's relatively simple compared to things like Campbell Lake. But, you know, this was a piece of property that I think was owned maybe by the homeowner association, but a neighbor said, gosh, this would make a great path. There's no sidewalks to the South High. He said, this is a great pathway through here to, so people could get to, you know, through the neighborhood without having to be on the road. It's really nice. So he worked and kind of talked to every neighbor, and I think there were about a dozen of them, and all but one said, yeah, that'd be fine. You know, it's not their property. It was just behind their properties. And he worked with the Parks Foundation and got a challenge grant. So he raised money from all sources to go in and essentially make a gravel pathway. And behind or adjacent to the one neighbor who didn't like it, he just skipped that. And so there's a little gap. And now it's in. It took him about 2 years, and he was just very persistent and very positive about it. And so that was a relatively easy one, but now it's a super nice pathway where one should sensibly be. And it's, I think, been very popular. So there are, you know, with patience, ability to kind of get these things resolved.
Thank you, Mr. Weddleton. So yes, there can be a happy ending, right? Ms. Pease, we have you in the queue again. Go ahead.
Yes, I typed a question in as well, so I just wanted to ask that be answered. And this also relates to the issue on Campbell Lake, where the previous member of the public said the property owner has said, no, there's no easement. We're working with DNR to prove that. In the case of many easements in my neighborhood, they're clearly there on the plats, but it's probably not going to go over as well to have me go knock on a door and say, I'm going to walk up the easement to take a look at it, versus having some sort of municipal letter or document that verifies that there's an easement here and the public can legally walk there. So what department and what process can the public use to have that sort of outreach come from the municipality and not from Joe Q Public?
Well, I absolutely, I mean, that is really the question. And I think that's what we're going to have to figure out how to answer correctly. And like I said, I in my area down Eagle River Valley, we have all kinds of public access issues where people basically think they can just walk through somebody's property because maybe maybe they've got 20 acres and they can just walk through that to get over the ridge into Ram Valley, and that's probably one of the most common ones. And again, people don't have good answers, and so I think if this could really, the way I look at it, this could be a really huge project. And like I said, I know the state is looking at trying to identify and determine actual public access, and I think we're going to have to do the same too. And if it comes down to trying to figure out how we do signing, this could be expensive. But I absolutely think that it's something that we have to have some kind of policy on, and we have to have definitive answers available. And right now we don't. So I think just getting our hands around what the big question is and how to figure out how to kind of move forward with developing some of the policies that we need to, and having a kind of a plan of attack, I think that's our next step. And so I can't give you any good answers right now, really, as to how we move forward specifically, but I know that we will. So I have Miss Allard. She's got something that she wants to say. So go ahead, Miss Allard, and then Mr. Weddleton.
Thank you, Miss Kennedy. And I'm gonna go along with Chris. If you need assistance or help trying to do this type of project, I'd like to jump on that team. And then I wanted to reach out to the gal that just spoke prior to you, Miss Kennedy. You answered her question, and to Lori, Miss Barter, if you guys could email me, I'd like to be able to talk with you guys. I just wanted to put that out there. Thanks, Miss Kennedy. Oh, great. This is Assemblywoman Allard. Okay, thank you.
Thank you, Miss Allard. Mr. Weddleton.
Thanks. So question to staff is, so where does money come from to do surveys of easements and then put the signs in if they're warranted? And I wonder, is that something that would bonds be the vehicle to do that? So if, some amount of money, $200,000, I'm just making the number up, we're added to the bonds specifically for easement research, easement verification, and signing. Is that a bonding thing, or does this come out of pure operating budget?
Through the chair, this is Chris Schutte, Economic and Community Development. The short answer is maybe. And the reason it's a maybe is because the survey as a function of larger development projects that are bonded is a common occurrence. So roadways, et cetera, and even non-motorized projects. But a bond issue just to send survey crews across the bowl to survey and or mark beyond what's already marked, I don't believe that would be bondable, but we will dig into it and get you some answers.
Great, thank you.
Great. Thank you, Mr. Weddleton and Mr. Schutte. And I guess, for me, that you mentioned something, Mr. Schutte, that kind of begs the question too, and that is really, how much public access areas are actually well marked already, and are we really talking about ones that are a little more obscure that we have to identify and make a little more public, or are they the ones that are just still being questioned and challenged? Anyway, another question as to how big of an issue is this right now in terms of having public access that maybe is challenged or questioned, and how many of those different sites and locations do we have within the municipality? Okay, so I've got a couple things here in the queue. Ms. Allard put her email address in there because that was requested, and Mr. Constant.
Thank you. So I think that kind of elides to another part of this conversation that is wise for us to look to, and that, so the question really was, how do we approach the questions that we have before us, and in terms of funding, in terms of kind of setting up a mechanism or mechanisms for addressing these concerns as they arise. And I see it in two ways. There's the squeaky wheel theory, that is, we target those places where we have public outcry and try to address real problems, real controversies, specifically as they arise. Then we have the broad question of how common is this? Where is it happening? What are the historic access points, and how do we address them? And so those are two very specific and different approaches, I think. And at some point they will converge. But the first one, I think we should take on and specifically work towards having a mechanism for addressing very specific places, which could be, from a funding perspective, us coming up with funding, whether it's through general funds, park foundation funds, bond funds. The public could run GoFundMe campaigns. If they're really controversial, people will spend money to provide access and figure it out. There's a number of paths there. And on the other side is probably figuring out a group of people who would work on behalf of us to do just that: create a catalog, create an approach, a question of how we would address them over time, so that we ensure we are doing two things. One, protecting the public access, and also protecting the private property interests near those public accesses, so we don't create areas of conflict like we have seen in a number of the hillside areas where we have very few access points and a lot of people who want to access. And so I think it's two approaches. One is the kind of putting out the burning fires, and two is a planned approach that creates a catalog of these and that we address them in a methodological way over time.
Thank you, Mr. Constant, and I see that too. And again, I'll just reiterate that both JBEAR and the state are working on this too. So we ought to be collaborating with them, because there's no sense in us, doing the same work. But they obviously recognize that there are access issues, basically, with the public from within the municipality. So we definitely need to be collaborating with them. JBEAR has been kind of trying to grapple with this for the last couple of years. And I think they're starting to get really serious about figuring out how to do the proper signage. And so, I want to help support them in their effort as much as they can support us in ours. So anyway, so I think we do need to put together kind of that group that will create these, a catalog, if you will, of these access points, and then figure out how we fund both developing those access points, putting the proper signage up, and like you said, Mr. Constant, really what's very important is to make sure that we're protecting private property rights. So definitely, I can see this kind of starting to formulate a little and gel a little bit. So I think we're going to get there. I think I've got Mr. Weddleton next.
Thanks. So just a thought after Krishuti's comment. We have a little bit of a parallels when we do traffic calming, where community councils nominate, certain roads or whatever, and then it goes to Tim Myland, and he evaluates them and prioritizes them some way, and then he'll choose some to do further studies, and then ultimately with some of those we'll do some kind of traffic calming. And I suspect typically that most of the cost, because generally what that means is a speed bump of some sort, and which are not spectacularly expensive. There's probably more time and money spent studying it than it is actually building the thing that results from it. But that kind of process, maybe, you know, community councils nominate these things and it's thrown in the hopper to be prioritized. And Christoph, possibly, I don't know if anyone there, I'd had some contacts with people worried about a Cheney Lake easement or easement access. And if they're online, if you, I know we just have a minute or two, but give them a moment to speak. I don't know if they're actually here or not.
Okay, well, we'd kind of opened it up to others in the public, but let me get to Mrs. Olatel and then I'll make that call again and see if there's anybody that wants to comment. So thank you, Mr. Weddleton. Mrs. Olatel.
Thank you, Chair. So along the lines of what Mr. Constant and Mr. Weddleton have been saying, I'm wondering if, so I like concrete next steps. And if one of the concrete next steps isn't to lay out some sort of resolution to bring forward to this committee to consider kind of stating, you know, what our policy goals are here to address this issue, that then kind of provide some guidance as we want to move forward. It can include, of course, the collaboration. You know, maybe it's that we want to investigate looking into a process like the traffic calming, and it can start to delineate the two issues that I think Mr. Constant raised, that there are just two different issues here right now that will probably converge again in the future, to give us a more concrete path forward. I think that's always good as we look at tackling what it seems to be quite a large issue. Thanks.
Thank you. Yes. Let's see here. So, Mr. Constant, go ahead.
Yeah, two things. One, I just, as much as I value the community councils, I want to make sure they aren't the place where people go, because, you know, we have witnessed community councils become effective tools of groups in opposition or in support. And this could be the reason why an entire executive board at a community council is tossed out. And so while we want their input, I don't want it to be the nexus. But we'll come up with that. And to the point that Ms. Zalatil made, and maybe working with Ms. Peace and Ms. Allard, we can draft up some form of resolution, and the chairs, of course, once we have something moving, to put before the committee.
No, that's great. And that's what I was going to suggest, was that we just kind of start a little bit of a working group to begin to really plan this out in some way, shape, or form. So I was happy to hear that you, Mr. Constant, and Ms. Allard have already kind of volunteered to champion this idea. So I think it would be wise for us to kind of let you do some preliminary, put some preliminary thoughts on paper. And I think Ms. Zalatel has the right idea. Once we kind of have a plan, you know, put some kind of a resolution forward to move on this, that'll help too. And, you know, and things just manage to flesh out, you know, it's just that getting started, which today is really a good getting started point. So I think we're heading down a direction, and so that looks good to me. I think it's positive. One thing I do want to do, though, before we sign off here, because we are up against the 11 o'clock time frame right now, to see if there is anybody else that came or is listening in from the public that wanted to comment or leave a question with us.
Hello.
Okay.
Hello?
Yes. Go ahead.
What about audience participation? It's on the agenda.
That's still on the agenda as well. Yes. But if you have a comment on this particular issue, I just want to make sure we've gotten everybody on this particular issue.
Okay. So I'll wait till audience participation. Thank you.
All right. Thank you, Mr. Haberman. So anyone else? We probably should extend for about 5 more minutes.
Move to extend.
Thank you. Is there a second?
5 minutes.
Okay. And is there a second?
Uh-oh.
Second, sorry, I couldn't get my button to work. Second.
Thank you, Ms. Zalatil. Okay, is there any objection? All right, so we're extended. Again, last call for anybody from the public that wants to present a question or has a comment in regard to our easement and right-of-way conversation. Or I should say public easement and right-of-way. Okay, I'm not hearing anything. So I think just in terms of moving forward, we will we'll begin putting together this group that's going to kind of champion this idea, and we will have more formalized way forward here soon. So looking forward to that. And so we'll go on to, I don't think we have any old business and audience participation. So whoever, I think we have Mr. Haberman that wanted to comment. So we're open to audience participation.
Okay, thank you. I'll set my timer. My name is Eugene Carl Haberman, Alaska resident for roughly 43 years, 20 years Anchorage resident, and currently a Valley resident, Metro Valley. Number one, I've said this from time to time on your committees, the situation, how you handle meetings before COVID occurred and how it's being remote now. The first item on the agenda dealt with a Voodoo cannabis company. You, as a committee, made a decision, you voted, but you didn't bring in and ask if there was any public comment. This is a serious situation that wasn't occurring pre-COVID time because the meetings were held over in Elmore. There was, excuse me, there was an identity to who was in the room, audience introduction, so that there was an identity for each one participating and involved and listening. And now you making decisions without bringing in public comment. You also, if you're going to say certain things have been sent to the assembly, complaint or whatever for against a particular item, one would have hoped to have been put on the website so that the public could see it, and not that you'd be making decisions on issues without the public seeing those that's before you and connecting with the public. And I'd like to close with this and raise my concern. The last several meetings at the Anchorage Assembly meeting, it's been going on for a couple of months, it's been really frustrating for me and for members of the public and for you all, because it's been getting more and more out of control, and we need to respect each other, listen to each other respectfully, and discourage the kind of things that have been happening at the Anchorage Assembly meetings, basically at the Assembly meetings at Blue Sack. And your setup right now is not helping things. And when I say you, I mean the way you have the meetings there. There's lineup for people in line, particularly in COVID time. This is not the time for that. There should be sign-up sheets like they do out in the Borough Assembly for each item, and prevent this kind of scenario. And to think that people in their years have to wait in line for 40, 50 minutes so they can wait in those lines that you have is not respectful at all. And it's frustrating, and it's encouraging an unhealthy situation dealing with COVID. And I'll leave you with this thought too, is remind you about state law, providing a reasonable opportunity for the public to be heard. It's even more important that you really look at how you're handling that in the times of what's going on in the country. The people need to be heard, but also at the same time, in closing, everyone needs to respect each other and listen to each other respectfully. And thank you very much, and I wish you all the best and Happy New Year.
All right, thank you, Mr. Haberman. Is there anyone else that wanted to comment? We still have a couple more minutes. So. All right, well, not hearing any other comments, and we're at 11:05, so I would entertain a motion to adjourn this meeting.
Move to adjourn.
So
Thanks,
moved.
Crystal.
Thank you very much. We are adjourned.
Thank you.